Good morning, everyone. This is the last topic from the CLOS, which is the extracts from the new civil code, and this is reported by Amoges, De La Torre, De Loso, Mada, and Solas, which is from the table of contents. De Loso, which is from the Article 264 to Article 270, and next is Salas from the Article 271 and to 274. Kay Imada mo to siyang sa Article 275 to 280. Kay De La Torre, which is pang-apat na reporter, is ang Article 281 to 285. Ang kay Amoges is the last reporter diri sa ang topic sa extract of the civil code, which is sa Article 286 to 289. Okay, so let's start sa Article 264 to 70. Ang extract of the civil code of the Philippines is muna siyang base halos tanan sa pledge, which is pakintabang sa pledges. Sa Article 264, which is the concepts and grounds for arising of pledge. First is the transfer by one person to another of property or rights thereto as security for an obligation shall be considered to be a pledge. Okay, ang pledge there is what is pledge? Ang pledge, which is a solemn promise or undertaking, a thing that is given as security for the fulfillment of a contract or the payment of a debt and is liable to forfeiture in the event of failure. So, basic example ani is kanang maro sa restaurant. Like, if sa restaurant, like, naman kay ubang table da nga kanang kailangan siya reserve. And ang katong reserve dito can be served as a contract, which is, ang contract dito is mo pa siyang naka-base dito nga nakapangalan si mo nga kung matawag sa restaurant, which is basically butanan ti mong pangalan and naka-reserve siya dito nga murag especially para nito sa inyo ha. And dito para sa iba. Ito ang ginatawag ko na ito nga contract. And napating natawag ito nga that type pledge is kung mag sa restaurant tapos wala kayong naka-reserve na seats o naka-reserve na table and then wala pa siya tawag dito. Wala kayo murag promise na nakabutang, which is diretso lang ka ng sulod na pala table and wala tayong naitabo ito nga pledge, which is andito naka-serve as a customer but doesn't have any pledge or ang promise na makasulod ito or as a reserve sa table. And what siyang ginayon natin nga, how is pledge created? To create a pledge must be in control of the pledge asset in a way which means the debtor can no longer interfere with the asset. The pledger must have a possession which can be actual or constructive. Okay. There is Article 264 sa number 2, which is sabotable na siya. The by virtue of pledge, the creditor with regard to an obligation secured by a pledge or pledge holder shall have the right in the event of the non-performance of the debtor of this obligation to receive satisfaction of the value of the pledge on property preferentially before other creditors of the person to whom this property or the pledger belongs, with the exception established by the law. So third is the pledge holder shall have the right to receive on the same principle satisfaction from the insurance compensation for loss or damage of the pledged property, irrespective of whose benefit was insured unless the loss or damage occurred for reasons for which the pledge holder is liable. Dala na sa pledge holder sa number 3, mura ng ginamin diri is that kung gina-pledge ng isa ka bagay or gina-contract sara, is dapat naman mag-equivalent exchange para napoy ma-compensate sa loss if ever man nga may tabo about sa katong pledge ninyo nga gibuhat. Okay, so number 4, which is ang pledge shall arise by virtue of a contract or on the basis of a law. So, ginabasa lang dito sa pledge is based siya sa law and it is not based lang sa kanang mga promise sa tao. And since sa tao lang man na siya, di mo siya masaligan because it doesn't have any credibility na to stand, it has any credibility, wala siya credibility to assure nga legit ang katong inyong ginabuhat na pledge, which is need na to na contract and need the basis of the law. Okay, so next there is Article 265. Muna siyang types of pledge. So first is a pledge may be in the form of pawn, mortgage, and also a pledge of rights. Second, a pledge under which the pledge property is transferred from the pledger to the jurisdiction of the pledge holder shall be deemed to be a pawn. And three, a pledge the subject of which is movable property shall be deemed as a mortgage. Under sa type of pledges, bali, pwede na tayo mag-focus sa ginaturo niya form of pawn, mortgage, and sa pledge of right. Ang pledge or pawn is, or there's a pawn, ito siyang payment of personal property as security for some debt or engagement. So, I mean, what does it mean when something is in pawn? So something delivered or deposited with another as security for loan or something used as a pledge. And sa mortgage, mo siyang legal agreement by which bank or other creditor lends money at an interest in exchange for taking a title of the debtor's property with the condition that the conveyance of title becomes void upon the payment of a debt. Mura siyang sa type of pledge is some forms of loan, which is mura siyang by contract. And sa mortgage, it is in forms of property na na-establish na. Okay. Ang pledger, which is bisa na kayo siya makasapatataw sa pledger. So, pledger, so first, either the debtor himself or a third person may be a pledger. Mura siyang mag-witness dito sa pagbuka sa pledge. Okay. The owner thereof may be the pledger of a thing. The person to whom pledge right belongs may be the pledger of the right. The pledge of the right to a thing shall not be permitted without the consent of the owner unless provided otherwise by law or by the contract. Okay, so Article 266, which is a pledger. Pledger is the person who deposits something as a security for the fulfillment of a contract or the payment of a debt. A pledger is a debtor who gives a pledge on an asset to a creditor. So, mo na siyang a main point or something na driving force dira sa pledge or mo to siya ang founder sa pledge. Nga pagbuhat mo sa pledge dapat na kay mag-witness and sa witness nimo is mo to siyang pledger nga nagkapagmatuod nga na kay pledge nga ginabuhat. Okay. Article 267 is subject of pledge. Subject of pledge is sabotable na ka siya nga topic. Since sa subject of pledge, based sa definition, not any property including things and property rights or demands may be the subject of pledge except for the things withdrawn from turnover mo na to siyang murag dili na siya appel sa pledge which is murag sa imo na to siyang property nga gitanggalin mo. Pasensya lang sa sa background. So, demands inextricably connected with the person of the creditor, in particular demands concerning. So, subject of pledge in this case is special property possessed to the pledge sufficient to enable him to maintain an action against a wrongdoer. But general property, it is the property subject to the pledge remains in the pledger. So, ang pledge lang ay ginaya lang diri sa subject of pledge is mo to siyang murag property lang na may ginatagaan og pledge. Okay, diri sa Article 268, demand secured by the pledge. So, sabotable lang po siya nga topic. Based sa secured by pledge. So, unless provided otherwise by contract, a pledge shall secure the money in that amount which it has at the moment of satisfaction in particular interest and penalty, compensation of losses caused by delay of the performance, and also compensation of necessary expenses of the pledge holder for maintain of pledge thing and expenses relating to recovery. Ang ginamdura sa demand secured by pledge is something na kanang murag na kay credibility na puta na to nag-loan ka. And sa pag-loan nimo dito, wala kay kanang trabaho nga makaya na mabayaran ang katayo mong ginaloan. So buta na to kwan. Nagpalit ka og sa Bugatti. Nagpalit og Bugatti tapos imong trabaho lang is tambay. So dili ka nila pwede papalitan og Bugatti is because tambay na ka. Wala kay murag background na paano naman na pwedeng may credibility na kaya nimo siya paliton. Mo to siyang ginatawag na secured by pledge. Murag Gadawat sila as long as ikaw as a person is credible ka and masaligan ka nga nakaitrabaho nga ang katong ginaluni mo is kaya mo siya paliton or kaya mo siya bayaran. Mara tang ginatawag natin diri sa secured by pledge and pledge with and without transfer of pledge property to pledge holder. Basically mo na siyang pledge property shall remain ang ginamit lang diri sa sa Article 269 is nakabase lang siya sa condition sa pledger or based sa pledge. Ang pledge property should remain with the pledger unless provided otherwise by a contract. Ang property in which is established and also pledge goods in turnover shall not be transferred to a pledge holder. The subject of pledge may be left with pledger under lock and seal of the pledge holder. Ang diri sa tray is murag mo na to siyang ginatawag na pag may seal which is ang credibility or ginatawag na to sa isa ka permit natay ginatawag nga firma. Saan ito? Okay. Number 4 is the subject of pledge can be left with the pledger with the imposition of marks testifying to the pledge. Firm pledge. The subject of pledge transfer by the pledger for a time in possession or use to third person shall be considered to be living it with the pledger. So 6 is in the event of pledge of a property right certified by security type, it shall be transferred to the pledge holder and act disposition notary unless provided otherwise by the contract. Okay. Okay, sa last topic na diri about sa Article 270 which is the origin of right of pledge. The right of pledge shall arise from the moment of conclusion of the contract and pledge or if the contract is subject to notarial certification from the moment of notarial certification in the event of obligatory registration of the contract from the moment of registration thereof. So based na diri sa origin of right of the pledge, mo to siyang the right of pledge is a right held by ng obligee to obtain satisfaction of his credit out of the value of personal property or property of which he has received possession of the obliger or third party as a security for such credit in preference to other obligee. And one of the topic now regarding sa Article 264 to Article 270 sa extracts of the Civil Code. And next topic is reported by Mr. Noel Shamsalas. Thank you.
Thank you for that wonderful intro. Okay, once again, good morning everyone. My name is Noel Shamsalas and I will continue the report here. Article 271 to 274. Article 271. Contract and pledge, its form and registration. Number 1. In the contract and pledge must be specified by the subject of pledge and its valuation, the essence, amount, and period for performance of the obligation secured by the pledge. It also must contain an indication of with which of the party the pledge property is situated. It's clear na dapat sa isa contract of pledge kasabot ang both sides kung unsa at stake o unsa ang ilang gipirmahan within the contract. Okay, number 2. A contract on pledge must be concluded in written form. Nga naman, kay ang written form lang ang tangible value which the verbal form didn't. Kay kung magipit ka tapos maingon ang i-deny sa pika side kung ang inyo about sa inyo ang contract, wala kay ma-present as evidence na naamoy na pagkasunduan kung verbal. Okay, continue. Number 3. A contract on mortgage and also a contract on the value the pledge of movable property or rights to property to secure obligations which must be notarily certified shall be subject to notarial certification. Here. Number 4. A contract on mortgage must be registered in the procedure established for the registration of transactions with the respective property. So, dapat registered siya before siya mag-proceed to any more of the transaction or before the contract is been established. Number 5. The failure to comply with the rules contained in paragraph 2, 3, and 4 of the present article shall entail the invalidity of the contract on pledge. Very clear and suboptimal. Article 272. Property to which rights of pledge holder extend. Hantod asa man jud ang rights or legal protection sa isa ka pledge holder. Number 1, the rights of the pledge holder or right of pledge to a thing which is the subject of pledge shall extend to its appurtenances unless provided otherwise by the contract. Which is tanan parte sa new civil code nun is bounded by the contract. Unless na wala siya na state, the pledge holder don't have any problems with it. Number 2, the right of pledge shall extend to fruits, products, and revenues received as a result of the use of the pledge property in the instant provided for by contract. Number 3, in the event of the mortgage of an enterprise or other property complex as a whole, the right of pledge shall extend to all of the property comprising it, movable or immovable, including the rights of demands and exclusive rights. Among them, those inquired during the period of the mortgage, unless provided otherwise by law or contract. Number 4, the mortgage of the building or installation shall be permitted only with a simultaneous mortgage under the same contract of the land plot on which this building or installation is situated, or the part of this plot functionally ensuring the pledge object, or the right of lease of this plot or corresponding part thereof which belongs to the pledger. Number 5, in the event of the mortgage of the land plot, the right of pledge shall not extend to buildings and installation of the pledger situated or erected on this plot unless a condition provides otherwise in the contract. Number 6, in absence in the contract of such a condition, the pledger shall, in the event execution is levied against the pledged land plot, retain the right of limited use or servitude of part thereof which is necessary for the use of the building or installation in accordance with its designation. Conditions for the use of this part. Number 7, if a mortgage has been established on a land plot on which a building or installation is situated which belongs not to the pledger but to another person, then when the pledge holder levies execution against this plot, and in the event of its sale at the public sale, to the acquirer of the plot shall pass the rights and duties which the pledger had with respect to this person. Number 8, the pledge of things and property rights which the pledger acquires in future may be provided for by the contract on pledge, and with respect to a pledge arising on the basis of the law by the law. Okay, Article 273, a subsequent pledge, which is a pledge na napagkasundoan na before the kind of pledge will be implemented. Number 1, if property under pledge becomes the subject of yet another pledge to secure other demands or subsequent pledge, the demands of the subsequent pledge holder shall be satisfied from the value of this property after the demands of preceding pledge holders. Number 2, a subsequent pledge shall be permitted if it's not prohibited by the preceding contracts on pledge. Number 3, the pledger shall be obliged to communicate to each subsequent pledge holder information about all of the existing pledges of the particular property and shall be liable for losses caused to pledge holders by the failure to fulfill this duty. Now we're on Article 274, Content and preservation of pledge property. Number 1. The pledger or pledge holder, depending upon which of them has the pledge property stating on Article 269 of the present code, shall be obliged to, unless provided otherwise by law or contract, to number 1. Ensure pledge property at its full value at the expense of the pledger against the risk of loss or damage, and if the full value of the property exceeds the amount of the demand secured by the pledge, for the amount not lower than the amount of the demand. Number 2. Take measures necessary in order to ensure the preservation of the pledged property, including to defend it against infringement and demands on the part of third persons or third parties. Number 3. Inform immediately the other party concerning the arising of the threat of loss or damage to the pledged property. Okay, number 2, without open and close parenthesis, the pledge holder and the pledger shall have the right to verify the documents by documents and the actual existence, quantity, state, and conditions of keeping the pledged property situated with the other party. Well, in the event of flagrant violation by the pledge holder of the duty specified in paragraph 1 of the present article, which create a threat of loss or damage of the pledged property. Thus, the pledger shall have the right to demand the termination of the pledge before time. I hope you understand it, guys. I'm now please welcome Mr. John Mark Imada for its report. Once again, thank you for listening.
Good day, everyone. My part of the topic is from Article 275 to 280. Article 275. Consequences of loss of or damage to pledge. The pledger shall bear the risk of accidental perishing or accidental damage to pledge property unless provided otherwise by the contract on pledge. The pledge holder shall be liable for the full or partial loss of or damage to the subject of pledge transferred to him unless it is proved that he may be relieved of responsibility in accordance with Article 333 of the present code. Number 3. A pledge holder shall be liable for the loss of the subject of pledge in the amount of its real value, and for the damaging thereof, the amount by which the value was reduced, irrespective of the amount at which the subject of pledge was valued when transferring it to the pledge holder. Number 4. If as a result of damage to the subject of pledge it has so changed that it cannot be used for its express designation, the pledger shall have the right to reject it and to demand compensation for the loss thereof. Number 5. The duty of the pledge holder to compensate the pledger also for other losses caused by the loss of or the damage to the subject of pledge may be provided for by a contract. Number 6. The pledger, who is a debtor with regard to the obligation secured by a pledge, shall have the right to set off the demand against the pledge holder concerning compensation of losses caused by the loss of or damage to the subject of pledge in repaying the obligation secured by the pledge. Next article is substitution and restoration of subject of pledge. Number 1. The replacement of the subject of pledge shall be permitted with the consent of the pledge holder unless provided otherwise by law or by contract. Number 2. If the subject of pledge has perished or is damaged or the right of ownership to it or the right of economic jurisdiction has been terminated on the grounds established by a law, the pledger shall have the right within a reasonable period, and in the event of a dispute within the period established by a court, to restore the subject of pledge or substitute other property of equal value unless provided otherwise by the contract. Article 277. Use and disposition of subject of pledge. Number 1. The pledger shall have the right unless provided otherwise by contract, and it follows from the essence of the pledge to use the subject of pledge in accordance with its designation, including to derive fruits and revenues from it. Number 2. Unless provided otherwise by a law or contract, and it follows from the essence of the pledge, the pledger shall have the right to alienate the subject of pledge, to transfer it on lease or for use without compensation to another person, or otherwise to dispose of it with the consent of the pledge holder. Number 3. An agreement limiting the right of the pledger to bequeath pledged property shall be void. Number 4. The pledge holder shall have the right to use the subject of pledge transferred to him only in the instances provided for by contract, regularly submitting a report on use to the pledger. The duty may be placed by contract on the pledge holder to derive fruits and revenues from the subject of pledge for the purposes of repaying the principal obligation or in the interest of the pledger. Next article, defense by pledge holder of his right to subject of pledge. The pledge holder with whom the pledge property is situated or should be situated shall have the right to demand and obtain it from another illegal possession, including from the pledger. Number 2. In instances when, according to the conditions of the contract, the pledge holder has been granted the right to use a subject of pledge transferred to him, he may demand from other persons, including the pledger, the elimination of any violations of his right, even though these violations were not linked with deprivation of possession. Next article, grounds for levying execution against pledged property. Number 1. Execution may be levied against pledged property in order to satisfy the demands of the pledge holder creditor in the event of the failure to perform or the improper performance by the debtor of an obligation secured by the pledge under circumstances for which he is liable. Number 2. Levy of execution against pledged property may be refused if the violation of the obligation secured by the pledge which was permitted by the debtor is extremely insignificant in the amount of the demands of the pledge holder as a consequence thereof is clearly incommensurate with the value of the pledged property. Last article. Procedure for levy of execution against pledged property. Number 1. The demands of the pledge holder or creditor shall be satisfied from the value of pledged immovable property by decision of a court. Number 2. The satisfaction of the demand of a pledge holder at the expense of the pledged immovable property without recourse to a court shall be permitted on the basis of a notarially certified agreement of the pledge holder with the pledgor concluded after the grounds arise to levy execution on the subject of pledge. Such an agreement may be deemed by a court to be invalid upon the suit of the person whose rights were violated by such an agreement. Number 3. The demands of a pledge holder at the expense of pledged movable property shall be satisfied by decision of a court unless provided otherwise by agreement of the pledger with the pledge holder. Execution may be levied against the subject of a pledge transferred to the pledge holder in the procedure established by the contract on pledge unless a different person has been established by a law. Number 4. Execution may be levied against the subject of pledge only by decision of a court in instances when, number 1, in order to conclude a contract on pledge, the consent or authorization of another person or agency is required. Number 2, property having historical, artistic, or other cultural value for society is the subject of pledge. Number 3, the pledger is absent and it is impossible to establish his whereabouts. The next reporter is to be reported by Mark Lloyd de la Torre.
Good afternoon. Good morning. My name is Maria de la Torre, and I am the assigned reporter for the topic Article 281 to 285. So in this discussion, ano lang siya serve as a refresher and also murag i-review lang siya with regards to the recent topic which we discussed by the reporters. So let us start. So Article 281, which is the realization of pledged property. So once may the realization of pledged property, napasabot ani siya is ibaligya or to be sold certain kind of pledged property. So before that, let us first introduce or i-review nato ang upat. So first is ang pledge. Next is the pledger. Third is the pledge holder, and lastly is the pledge property. So once naman yung tag-pledge, so review lang niya. So once naman yung tag-pledge, it is somehow a promise or agreement in such point na magkaroon ng collateral for the payment of a debt or the performance of an obligation. So next, for example, si Mada, nangutang siya kay Shem. So si Mada will be considered to be the pledger or the debtor or nangutang. Next is si Shem will be considered to be the pledge holder or siya tong nagpautang. And lastly, nagkaroon sila Kimada o si Shem og agreement like si Kimada pero mo kog kwarta isang la na ko sa imo ha ang ako ang property. So katong property na gisanga ni Kimada is mo tong gitawag nga pledge property. So let us begin. So one pledge property against which execution is levied in accordance with Article 280 of the present code shall be realized or sold by means of sale at public sale in the procedure established by legislation. So next is at the request of the pledger, the court shall have the right in deciding to levy execution against pledged property to give for the sale thereof or the public sale for a period of up to 1 year. So the deferral shall not affect the rights and duties of the parties in regards to an obligation secured by the pledge of this property and shall not relieve the debtor for compensating the losses of the creditor and penalty which grew during the period of deferral. So ang pledge holder or let us put it on the perspective lang sa pledge holder. So for example, wala na bayaran ni Kimada, wala na fulfill ni Kimada katong the right amount na kwarta na giutang niya. So the pledge holder has the right like di ba gisang la na property si Kimada kay Shem. So in order para mabayaran si Shem had the right na to sangla the property. But take note, si Shem has no rights pa, wala pa siya rights pa to to give a specific amount of sale or price sa pagbaligyan niya into public. So dila na magsulod ang the court. So the initial sale price of pledged property at which the public sale begins shall be determined by decision of a court in the instance of levying execution against property in a judicial proceeding by agreement of pledge holder with the pledger in other instance. So di ba like magkaroon pa siya certain kind of investigation, magkaroon pa na siya mga certain kinds of discussion and also ang mga mga documents and other further details need po na siya i-process in order para i-release tong the right amount of price for the sale. So 4 is the pledged property shall be sold to the person who offered the highest price at the public sale. So it's very common like once may utang bidding, so kung sino mas higher price mo to ang madaog. So when a public sale is declared to be unconstituted, a pledge holder shall have the right by agreement with the pledger to acquire the pledged property and to set off against the purchase price his demand secured by the pledge. So the rules concerning the contract of purchase or sale shall apply to the agreement. So, di ba, like, once na magkaroon of, um, uh, I mean, maging unconstituted, kung maging unconstituted is, wala siya nag-work or wala nag-make sense ang declaration. So, ang pledge holder is na siya rights of agreement with regards to sa pledger not to acquire the pledged property and siya mismo ang mag-set of price based on his demand and based on their agreement. So, motto. So, 6, in the event a second public sale is declared to be unconstituted, the pledge holder shall have the rights to retain the subject of pledge, valuing it an amount not more than 10% less than the initial sale price at the second public sale. So, nahitabo na sad. So, pero karon is sa public sale, I mean sa second public sale. So, ang pledge holder is na siya right to hold the subject with regards sa pledge and in which na po siya rights to increase more than 10% which is less than sa initial sale price at the second public sale. So next is if the pledger does not take advantage of the right to keep the subject of pledge within a month from the date announcement of the second public sale undisputed, the contract of pledge shall be terminated. So kanang termination will be discussed unya. So if the amount received when realizing the pledge property is insufficient to the cover of the demand of pledge holder, he shall have the right in the absence of an indication in the law or contract to receive amount in arrears from other property of the debtor, so which does not enjoy a preference based on the right of pledge. So during the situation is naging insufficient ang amount, and then wala to ng nag-reach dito sa silang agreement. So si pledge holder has the rights to like mag-move other property kay debtor, which is in order for him to fulfill his demand or to cover the demand sa niya or for of the pledge holder. So next is iba na po na scenario. So if the amount received in the event of realization of pledge property exceeds the amount of the demand of pledge holder secured by the pledge, so the difference will be returned to the pledge holder. So kung naging sobra-sobra na po, itong sobra na to will mabalik kay pledger. So matun mo pa sa to. So realization of pledge on property. So a debtor or pledger who are a third person shall have the rights at that time until the sale of the subject of pledge to terminate the delivery of execution on and the realization thereof. So having performed the obligation secured by the pledge or that part thereof whose performance has been delayed, an agreement limiting this right shall be null. So umata sa realization of pledge property. So lastly is next is the performance of obligation before time secured deliver execution against the pledge property. So pledge holder have the right to demand the performance before time on obligation secured by a pledge in instance of first is so sorry like sa section na ni is i-dictate lang na ako siya kay basically ano mo siya ang thought niya is more on reading mo siya. So also like isip ko siya i-explain kay kung ano mo siya like given a good thought. So sorry if discuss na ko siya like in a reading way So the subject of pledge departed from the possession of pledger with whom it was left in violation of the condition of the control on pledge. So pangalawa is a violation by the pledger of the rules concerning substitution of the subject of the pledge, which is under siya sa Article 276 of the present code. So motong discuss ni Timada na. So loss of subject of pledge under circumstances for which the pledge holder is not liable if the pledger has not taken advantage of the right provided by the Articles 276, paragraph 2 of the present code. So next up is ang ano daw, the pledge holder shall have the rights to demand the performance before time of obligation secured by pledge, and if this demand is not satisfied, to legal execution against the subject of pledge in an instance of. So a violation by the pledger of the rules concerning subsequent pledge. Second is the failure of the pledger to fulfill the duties relating to the maintenance and preservation of pledged property provided for by Article 274, paragraph 1, subpoint 1 and 2, and paragraph 2 of that present code. So third is a violation by the pledger of the rules concerning the disposition of pledged property, Article 277, paragraphs 2 and 3 of that present code. So dinata sa termination of pledge. So kaya termination of pledge agreement is ano na ko siya kay kaning i-summarize lang ako siya kay tingnan kay ang tot, and like kung basa-basahon pa na ako each sections is medyo madugayan po and medyo boring po. So i-generalize lang na ako termination of pledge agreement. So di ba, like upon the obligation termination date, so the pledge of the securities here under shall immediately terminate without further act by any always remember shall immediately terminate without further act by any party. So it's both the pledger, which is the pledger or the debtor, and also the pledge holder. So and mga requirements, mga covenants, and mga condition which contain within this pledge agreement relating to the obligation shall automatically siya ma-terminate. And the obligation terminate date shall means that the due upon which the payment and performance in full of obligation shall have been made. So always remember that. So malang term lagi generalize na ako tong mga thought diri sa termination. So motto. So next is the preservation of the pledge in event of transfer of right to pledge property to another person. So iyan na po na ako siya tatawagan generalize kay since kung isa-isa po na ako is murag po siya murag madugayan po. So once may magkaroon og transfer of right pledge property to another, pasabot lang siya that in connection with any transfer or assignment of the put right, so the pledges may transfer. So the pledges, which is katong pledger, not share rights to transfer all or any part of pledge shares, and the transferee shall thereupon succeed to all the rights, powers, and remedies granted the pledges hereunder with respect to the pledge shared, so transferred. So upon such transfer, the pledges shall be fully discharged from all liability and responsibility for the transferred pledge shares. So wala na responsibility ang ang I mean ang pledge ang pledger with regards kay since na transfer na niya to ang pledge niya to one another. So always take note po like for example like magkaroon ka og certain kind of a pledge agreement. Only one property is valid na siya. Kunyari nakaisa ka property which is the-pledge nimo, katong property na to will be valid for one agreement lang siya. So di mo siya magamit in a certain kind of transaction or pledge na po. So mo lang to. So motong brag sense aning katong generalize sa gayon na. So next is consequences and compulsory withdrawal of pledge property. So ayan na siya misa. I think understandable naman natin siya. So if the right of the ownership of ledger to property which is the subject of pledge terminates on the ground and in the procedure established by a law as consequence of withdrawal, so first state needs requisition or nationalization, other properties or respective composition shall be granted to ledger. So in the instance when the property which is the subject of pledge is withdrawn from the pledger in the procedure established by a law on the ground that in reality the owner of this property is another person. So which is the stated siya under the Article 228 of the present code. So or in the form of sanction of for the commission of crime or another violation of law. So the pledge with respect to this property shall terminate. So in the instance provided for the paragraphs 1 and 2 of the present article, the pledge holder shall have the right to demand performance before time of obligation secured by the pledge. So, muna to ang end sa kong topic and I hope na mo rin nasabtan. So, next reporter will be JD Amogues. So, that's all. Thank you.
Hello, good morning, guys. This is my report. I'm JBB Amoges, and this is my report is Article 286 to 289. So first is Article 286 assignment of right regarding contract on pledge. First is a pledge holder shall have the right to transfer his rights under a contract concerning the pledge to another person while complying with the rules on the transfer of the rights of a creditor by means of assignment of a demand. So, this present in Article 313-321 of the present codes. Next is 2. The assignment by pledge holder of his rights under a contract on pledge to another person shall be valid if rights of demand against the debtor regarding the principal obligation secured by pledge have been assigned to the same person. Next is 3. And so far as not provided otherwise, the assignment of rights under a contract on mortgage shall also mean the assignment of rights relating to the obligation secured by the mortgage. So, next article to discuss is Article 287. First is transfer of debt regarding obligations secured by pledge. First is, with the transfer of the debt regarding to obligations secured by a pledge to another person, the pledge shall terminate unless the pledger has been given consent to the creditor to be liable for the new debtor in Article 322 of the present code. Article 288, Pledge of Goods and Turnover. So, one, a pledge of goods while leaving them will the pledger and granting to the pledger the right to change the composition and natural form of the pledge property. So, reserve, good reserves, raw materials, semi-fabricated, finished product, and the like, on condition that their total value does not become less than the specified in contract on pledge, shall be deemed to be pledge of goods and turnover. Next is Next is 2. A reduction of value of the pledge goods and turnover shall be permitted commensurately with the performed part of obligation secured by pledge unless provided otherwise by the contract. 3. Goods in turnover alienated by a pledger shall cease to be the subject of pledge from the moment of their transfer into ownership, economic jurisdiction, or operative management of the acquirer, and goods acquired by the pledger which are specified in contract on pledge shall become the subject of pledge from the moment the right of pledger arises to ownership therein. In fourth is, in the event of violation by the pledger of the condition of the pledge of good in turnover, the pledger shall have the right by placing his mark and seals on the pledged goods to suspend operation with them until the violation is eliminated. So next, Article 289, Pledge of Things in Pawn Shop. So first is the acceptance from citizen on pledge of movable property intended for personal consumption to secure short-term credits may be effectuated as entrepreneurial activity by specialized organization, pawn shop having a license for this. So second, a contract on pledge of things in a pawn shop shall be formalized by the insurance of pledged ticket by the pawn shop. 3. The pledged thing shall be transferred to the pawn shop. And fourth, the pawn shop shall be obligated to insecure to the benefits of the pledger at his expensive things accepted on pledge for the full amount of their value established in accordance with price for things of this type and quality at the moment of their acceptance on pledge. The fifth is the pawn shop shall not have the right to use and dispose of pledged things. Six is the pawn shop shall bear responsibility for loss of and damage to pledged things unless it is proved that the loss or damage occurred as the consequences of insuperable force. So as in 7, in the event of the failure to return the amount of the credit within the established period secured by the pledge of things to the pawn shop, the pawn shop shall have the right on basis of an endorsement of execution of a notary upon the expiry of the grace month's period to sell this property in the procedure established for the relationship realization of pledged property in Article 281, Paragraph 3 to 4, 5, 6, 7, 9, and 10 of the present code. So 8. The rules for granting credits to citizens by pawn shop under pledge of things belonging to citizens shall be established by legislation. And number 9, the condition of the contract on pledge of things in a pawn shop limiting the rights on a pledger in comparison with the rights granted him by the present code and by other laws shall be none. So that's all to our report. Thank you and have a good day.